you for joining us. We really appreciate you being here this afternoon. As you all may know, Alvin Ajay, our current HYLA president, one of his emphases this bar year has been on solos and small firms. One of the ways we've been helping to support that mission through the CLE community is bringing topics like this one. So this is part 2 of a 2-part series we have on advising small businesses. In November, you all heard from Ali Gutierrez for part 1. So this is part 2, talking about more sophisticated planning strategies. We have some great speakers here today. My name is Daniel O'Neill. I'm a professional liability defense lawyer at Thompson Co. So I'm going to be speaking on one of these sessions towards the end about ethics, which I know is everybody's favorite topic. So for now, I'm going to go ahead and turn it over to Kip Haines, who's going to introduce speakers, and then we're really excited about getting this presentation underway. So Kip.
Thanks, Daniel. So yeah, like he said, today we're going to talk a little bit about buy-sell. Christo, who is an expert on the business planning side, he has over 18 years of experience working with several businesses, business owners, everything in this arena. He's going to be doing the presentation. Like Daniel said, he'll then jump in, and then Sarah will wrap it up for the younger lawyers, really speaking on student debt and how we can tackle that with some of the current policies and regulations right now. But we're really excited to be here. Me and Christo come from a long line of attorneys in our family from Louisiana and the Houston area, so we're glad to be able to give back. And before we get started, I'll talk a little bit about our company, and then we'll get y'all started and get everything going here. Can you see my screen all right, Daniel?
Yes, perfect.
Good deal. So really the reason why me and Christo exist and why Wealth Design Group exists as a firm and our purpose is to empower families to experience purpose, freedom, and abundance. And we do that through our mission, which is to inspire and coach families on the truths of investing and design a plan that really supports their purpose. So we do that through several key areas of planning. The 4 main ones are protection. We coach families on eradicating exposures to financial threats. That could be anything from having your buy-sell in place from your business to, personal protection. We handle investments as well. We really focus on math and science with empirically tested Nobel Prize winning strategies. We focus a lot on tax strategies. Obviously, when you're accumulating wealth through small or medium-sized businesses, a lot of time you're in a high tax bracket, and we know what comes with accumulating wealth, tax burden. So we definitely want to handle that. And then lastly, in the realm of optimization, we're going to help and focus on cash flow starting today all the way into clients' retirement. We can really help you guys, clients, with that, as well as you personally. So with that being said, our company values are love, family, integrity, excellence, and enthusiasm. With that being said, that's a little bit about our company, and I'll let Christo get into the main presentation.
Great. Thank you, Kip. I appreciate it. First of all, real quickly, I'd like to acknowledge Daniel for putting this together. The topic is of interest. It's also, there's a lot of material. We're going to go, kind of 30,000 feet here, and we're going to move quickly. But by all means, it's not going to be exhaustive. I will say this, there will be some times where maybe it sounds like I'm reading, and I will be. Due to the nature of the CLE and for compliance purposes, there are some things that will need to be included. If there are things that we don't touch on or don't go into too deeply, everybody has an opportunity to reach out, and we can go into a little bit more depth or answer questions should we not do Q&A today. So with that, who needs a buy-sell agreement? Do you mind going back one? And I would ask you this: are you currently discussing business continuation with your current business owner clients? Business continuation strategies they're really integral and inextricably linked to a well-structured estate plan. In fact, when a business owner dies or is disabled without a plan, a business succession plan or a buy-sell agreement, the There's some studies that show that sales often flounder. There may be layoffs as the organization struggles to stay afloat. These studies show that upon the death of a founding entrepreneur, it can wipe out an average of 60% of a firm's sales and can cut jobs by roughly 17%. There are a lot of things go into play that makes that happen. Some that you probably think of off the top of your head, and others will go into it. But every owner, co-owner of a business should be thinking, hey, what happens to my business if I were to pass away tomorrow? What plans do I have in place for what will happen to my ownership if I become disabled? What happens to the business if I retire or when I scale back? One caveat to who needs a buy-sell agreement. First, I would say everybody, but then I would say the business needs to be successful first. If the business is actually struggling to stay afloat, then the owners may have much bigger personal planning requirements than worrying about business succession. So there may not be a need for a business succession or buy-sell plan. Mechanically, who will keep or buy an interest in a closely held business on the death or disability of a co-owner or partner? So there are people who might, by one way or another, take over your client's share of a business, a partner in a partnership, co-shareholder in a closely held corporation. In fact, the company itself may be in a position to buy that owner's interest out. But don't forget about employees. Businesses are oftentimes continued by the employees who help the owner build that business in the first place, right? So someone who's not already a co-owner, such as an outside competitor or a vendor, may seek to expand their own business interests and may be a potential buyer as well. Of course, it's also possible your client may not want to be bought out, that he or she wants to leave the business, or if they own it all, their share of the business to their children, their heirs, or part of their overall plan is transferring the estates through estate planning. So these things are, again, inextricably linked. What is a buy-sell agreement? If we look at, jump forward one. So basically, it can be described as a business owner's will. And this phrase is used to any agreement that your client enters into to sell his shares at death, even if that agreement is not without a family member. So when does a buy-sell agreement trigger? Some of the triggering events are death, disability, retirement, or some other potential events. The purchase of the appropriate interest by the business or the remaining owners or the key persons or family members. So upon death, how does that ownership transfer? The need for a buy-sell agreement, obviously, advantages to the deceased estates is they immediately have liquidity for taxes and expenses. When an owner dies, the federal estate tax is typically due within 9 months after death and must be paid in cash. Another concern is generating income for the deceased owner's family, which has been disrupted clearly by the death. So a binding agreement that's basically set in a mutual agreed upon price, either actual dollar amount or a formula to arrive at that number, means that a potential buyer cannot force the executor to sell at a low ball price. There's an example, Joe Robbie Stadium in Florida was actually sold. So that was an exceptionally wealthy family. Can't remember the numbers, but I think at the time of Joe Robbie's death, the stadium was worth $80 million and the estate tax came due immediately. So they ended up having to sell that as a fire sale. So they lost close to half of the value of what that stadium was worth by having to satisfy the estate taxes. So these are like some of the disaster stories that can occur in those types of situations. The need for a buy-sell agreement. So in the situation of a buy-sell being triggered by disability, retirement, or death of the owner, the departing owner realized the transformation of business wealth to personal wealth that is transferred. If disabled, the money coming from the agreement can help to offset expenses that will continue until the former owner can get back on his feet. If retired, the money from the agreement will definitely be a source of retirement funds so the former owner can enjoy his or her golden years. Again, that's the transformation of the business wealth to personal wealth. advantages to surviving owners, as little as conflict as possible. If you look at what's in it for the buyer, look at it this way: the surviving owner of a business may not be terribly enamored with the idea of his former co-owner's widow being his partner. And that's likely what's going to happen without a buy-sell agreement in place. When the estate or departing owner walks away with cash and no further worries about the business, the surviving owner no longer has to have concern for themselves or the deceased heirs. The departing owner has no further voice in running the business. All shares will transfer to the surviving owner. The last point there is that the seller knows exactly what they would have to pay. The state can't start a bidding war between a person who was fully expecting to buy the business and some third party. So there is a pre-agreed price or formula in place to establish that fair and reasonable price. The other advantages, clearly are stability. Are you going to have issues with vendors or suppliers or clients if one of the relationships is suddenly gone? So the influx of money is key there. We talked briefly about the triggering events, obviously death, disability, retirement, loss of a personal license. It could be even a conviction of a crime that no longer allows them to be material participant in that business. So this is big, children and the business. When an owner has minor children or fairly young children that are adults, it's imperative for the buy-sell to take that into account. An owner would normally, for example, want to enter into a binding agreement with a co-shareholder or outsider when the possibility exists that his or her children are already working for the business and could be groomed to take over management. Another point here with children is, what about those that are inactive? Concept called equalization. I work real closely with a small business here in Houston, which will remain unnamed, but it was a father and two children that were involved in the business. There was a third child outside of the business. So upon the father's death, the two boys will take over the remainder of the business, but the third child, if there is a sense that he's being left out just because he didn't work there, how do you equalize for that? So that's part of the estate planning, but it wouldn't seem fair that if the two kids that were materially involved would have to give up a share of their business to someone who wasn't active in building that business. Again, it's impossible to consider business succession issues isolated from a business owner's estate planning issues. So clients, children in the business with a buy-sell agreement, when you're transferring the business to family members, an analysis must be made to determine if a buy-sell agreement is necessary, because the business may be able to, be transferred more efficiently with wealth transfer techniques such as a grantor, annuity trust. There could be installments. You could be in a FLLC or FLP. Really, a detailed discussion of each of these wealth transfer strategies is beyond the scope and our time frame for today, but we'd be happy to discuss those individually later should you have additional questions. So outside of the family, other potential buyers could be vendors, competitors, or even key employees. Buy-sell agreements are not just between co-owners. The important thing is that they find a buyer for an influx of cash upon death. If there are no co-owners or children to pass the business to, excuse me, the client can always look to these other outside forces who may wish to buy the business and run it as their own. Inside the company, but not family, you've got key employees, and they may be groomed to become owners, but they also may be integral to the success of the business. People who are critical to that success may not have the wherewithal to purchase an ownership share, and they might not have the temperament for being an entrepreneur. But if they've been loyal to your client, your business owner client, for many years, and your client has an agreement, especially if it's an outsider, to buy it out, where do they end up? Are they out in the street with severance pay? And a way to address this is to make sure that employment contracts have some language in there that that the employee will survive a change in the regime at the business. Another issue is that the company may not be worth as much if your star salesman or your computer whiz is no longer with a firm. So consideration should be factored into the price, particularly when selling the business to a non-owner. You can reduce the price of that business if key players are no longer going to be with the business. So buy, sells, and estate planning. You want to jump up? Great. So I'll stress this again, and because it's worth restating. If you're doing estate planning for any business owners, it is key that there's an element of business succession planning. Buy sells play a huge role for several reasons, not the least of which is legacy planning, but also fixing the estate value. If you're able to get a preset price for that business, there are some issues we'll discuss briefly later on step up in basis or lack thereof, which can be could be hundreds of thousands, if not millions of dollars, depending on the size of that business, that could be subject to estate taxes at whatever level they may be in the future. As you know, estate taxes are a moving target. Doesn't matter where you land on the political spectrum. The argument can be made that they're probably coming back and they're going to be worse than they were in their previous manifestations. So briefly talking about the estate tax value, there are really some significant estate tax implications on valuations of the business, especially when there's a buy-sell agreement in place. That we're going to go over 3 slides here quickly, but we could spend an hour on each one. So we're going to go real high level. Should you have additional questions, again, feel free to reach out to Kip and I one-on-one. There's a legal binding obligation on the part of an estate to sell the business interest at an agreed upon price when there's a buy-sell agreement in place. Merely having an option to sell is not sufficient. It leaves too much room for play, and therefore it doesn't fix the value of the business for estate tax purposes. Also, I mean, that agreement must be a bona fide agreement. The IRS will scrutinize business plans carefully, especially when family members are involved. The contract terms, they have to be substantially similar to what 2 parties dealing at arm's length would reach. So it's got to make sense. It can't be funny money. Again, it will be scrutinized. So really, you want to see what 2 family members are trying to avoid taxes, then it's going to be clear and it will be scrutinized, and nobody wants to deal with that. So what does valuation look like? See how we're doing on time here. Assume your client wants to know what your company is worth, either to avoid a problem we just talked about, or because he or she wants the best price when they sell to another person. They could look at other business owners. Sometimes it could be as simple to start to get to what that price would be. Kip and I own a business together. We could each sit in separate rooms and be asked, hey, if you were buying, what would it be worth to you to buy my half? Or if I was selling it to Kip, where would I come in? And he would do the same thing. And now we've got a starting point. Obviously, you can get an accountant to do a valuation. There are brokers that handle that specifically for particular businesses, as well as appraisers. You can come up with a fixed number or a formula for the time of debt. Again, that's real high level. There's a lot to it, but valuation is key and can't be overlooked. General methods that can be used would be book value. You can look at an earning-based formula or capitalization. If it is a stock-held company, it could be dividend-paying capacity. It could be a multiple on earnings formula. It could be an appraisal, which will include capital assets, or you can revert to Revenue Ruling 5960. If you haven't read that, you might want to pick it up tonight if you're ready to go to bed. So to get in kind of the meat and potatoes here on how these work, there are a number of ways to structure them and variations of each. First, we have 2 that look a lot alike, depending if you're a C Corp or an S Corp or an LLC. Those are the entity and stock redemption. There is a cross purchase, typically with a smaller amount of owners. And then there's a wait and see approach, which is basically a combination of each of those. And like the first one, the entity purchase, also commonly called like a redemption or stock redemption. A contract requires the entity, not the co-owners of the entity, to buy out to be deceased. So the corporation would buy out the remaining shares. The opposite is the cross purchase, and we'll get into more detail. And this is when the buyer is an individual, and the agreement is generally referred to as cross purchase, because even though it's not always the case, there are two or more owners, and each is personally liable to buy out the shares of the deceased. Again, Kip and I own a small business as equal partners. I would have to buy out 50% of Kip's share on his death, so his surviving spouse is not my partner, and she's flush with cash immediately. So let's see, we're kind of jumping ahead here. That looks good. So go to that stock redemption. So in a stock redemption, if you look at the blue circle here, we got $1 million corporation. It would buy insurance on person A and person B, the two owners. Let's kill off person B, owner B. That green box would be an insurance company, Guardian here in this example, that it's irrelevant. The insurance company would pay the proceeds back to the company in the blue dot. Beneath that, they would pay the benefit to owner B's family, therefore buying out owner B's stake in the business. Now on the far right, owner B has all the cash, but no ownership, no indices of ownership at all. In this example, they say if there's $1 million company, they buy $500,000 on each. This is where it gets a little tricky here. You got to note that as a result, there's a step up in basis afforded to B's estate. That's good news. B's estate will receive cash for the value of business. B's family is no longer dependent on the continuation of the business and participation in it to have income because now it's been sold. Person A now owns the entire business. His basis remains remains 50,000 because that's where he started in the business. But owner B is flush, no step up in basis. The other where you would buy policies or have an agreement on each other, and I should stop for a minute because what I'm showing you here is not just a buy-sell agreement. It is a funded buy-sell agreement. Because you can have anything written on paper, but if there's not a funding mechanism in place, then it's all for naught. Lawsuits will ensue. We will talk about alternate funding methods, but here we're showing insurance. So an entity purchase rather than the redemption looks identical. The difference is rather than a C Corp where you're buying back stock, this is an S Corp. So again, S Corp owns insurance on person A and person B in the amount of $500,000 each to equal the $1 million company value. On B's death, the company will take that death benefit, give it to person B, therefore buying out their share of the company. Person A is now full owner. End result here is the decedent's estate will receive a step up in basis. So that's big. Now, S Corps actually enjoy an accounting privilege known as the terminating tax year. And basically what that means is the remaining surviving shareholders can elect to terminate the corporation's tax year. The beauty of using life insurance funding here is that the S Corp operating on a cash basis accounting method, which most do, can use the life insurance proceeds in the following year, therefore receive that basis increase, which is shared by the remaining shareholders or individual owner, as the case may be. Cross purchase is the one that we see a lot with small, very closely held businesses. Two partners, result at death is there is no income tax due to B's estate. If that was due, the owner, person A would own the business outright. There is an increase in basis. And let's look at why on that. Bear with me. So the cross-purchase agreement, the agreement's really between the owners of the business. The business itself is not a party to the transaction. If the owner dies, becomes disabled, or otherwise just departs the business, the other owners are required to purchase the deceased or departing owner's business interest. Jump over to cross-purchase, and then let's go to the diagram here. So to look at this, here it looks a little bit different. So now the corporation does not buy the policies. I buy a policy on Kip, Kip buys a policy on me. Both $500,000, we're still using $1 million value. If person B dies, then the insurance company will pay person A as the beneficiary of the life insurance policy on B's life, the death proceeds. Then person A will use those proceeds to buy out person B's share in the company, therefore eliminating person B's estate being part owner in a business that they're not materially participating in. Again, the example where Kip does not want my widow to be 50% partner. On the cross purchase, at death, again, it's a $500,000 income tax-free benefit, which is used to pay off B's estate for their portion in the business. Now, person A owns the business outright. His total basis is only $550,000. In that example, he had paid $50,000 into an insurance contract that paid $500,000, but his basis remains $550,000. The final one, checking on our time here, I think we're good, would be a wait and see approach. And this is kind of a hybrid approach, most commonly referred to as wait and see buy sells. What it does is it defers the choice of going of the entity purchasing it or cross purchase until a triggering event occurs. And it's written into the language that way. In this approach, the entity is given basically a right of first refusal to purchase the deceased or departing owner's business interest. It does not, if it doesn't purchase that business interest, then the obligation passes to the co-owners. If the co-owners then don't purchase all the deceased interest in the business, then the company must complete the buyout. But it does provide some flexibility. So this, if you go to that next diagram, bear with me on this. It's kind of busy, but if you look at owner B or family estate. So the business has the first option to buy them out. If they choose not to, then owner A and owner B have insurance on each other that can be used to buy that out. If they choose not to, for whatever financial reason at that time, then the business is compelled by contract to make that purchase and make the second person whole. So if you look at a comparison here, I'm not going to go through all this, but the basic mechanics of the cross purchase is owners buy policies on each other, where the entity, the business buys a policy on each owner. And that'll become key down here in the disadvantages. Cross purchase, insurance is used to buy out the deceased owner's share of the business. With the entity, the business uses those insurance proceeds. Still, the end result is the same. The cross purchase, there's an addition to basis. So that's good for tax purposes. You do not have that advantage with the entity purchase, but as we discussed, there are some ways around that. The real disadvantage with a cross purchase is when you start getting beyond 2 owners. Because once we have 3 owners, we each have to own a policy on each other. 5 owners, same thing. You should pretty soon be at 25 policies. That would be a lot of fun for your insurance agent, not so much for those paying the premiums. So once you get beyond a certain number of business owners, the entity purchase is typically the tool that is used. Cross purchase, you can use personal funds. The cool thing about that is if it's not used to purchase out if say you sell the business, you and your partner sell it, well, you still have the cash value in that life insurance, which you can use for retirement, business loans, any number of things. So you do have access to cash value, even if a death never takes place. I mentioned earlier in our examples, we were showing insurance used as the funding mechanism, but that's not the end all. There are a number of things you could do. You could use surplus funds. You could start a sinking fund. You could make the buyout to the survivor's family in payments or installments. The surviving owner borrows to get the purchase price. It may be difficult considering circumstances if one of the owners dies getting a loan. Or obviously you could use life and or disability insurance. So we've got about 7 minutes. Surplus, some corporations may decide to use accumulated surplus. Some problems with that or a sinking fund is if a death occurs sooner than later, there may not be funds available. And that would apply to either surplus or KIP, a sinking fund. Next would be borrowing. As I mentioned, there may be some inability to get a loan after the death of a material partner or co-owner in a firm for a number of reasons. And credit lines might tighten up. The cost of borrowing could also be uncertain, considering where prevailing interest rates are at the time. And you just can't crystal ball that kind of stuff. So it could be prohibitively expensive, if not unavailable altogether. Installment plans can be used if the parties agree to it. It is a common fallback. The problem is, if I'm on the receiving end, I may prefer to have my cash, or my surviving spouse may prefer to have the cash up front than installments that are not guaranteed and are entirely contingent on the further success of that business. The final and most commonly used funding mechanism would be using life and disability insurance. Obviously, there are set costs. There is guaranteed cost recovery. It's typically the least expensive because you're leveraging premium dollars versus a set death benefit. Cash values also grow in there and are accessible for things other than the buy sell if stipulated in the agreement. And it can supplement a lifetime buyout. Let's see here. In conclusion, I mentioned this earlier. These types of plans for your business owners are so integral to the estate planning. One cannot be done in a silo without looking at the other one. It's prudent to ask all your business clients whether they have a buy-sell agreement, how recently was it drawn up. In that connection, you may want to see what the price formula of the valuation was. Because with your knowledge of the client's business, you may decide that it greatly undervalues the asset that they're trying to protect. All the appropriate triggers should be included in that agreement. In addition, the data on the agreement and the identification of the parties to the contract will be key to whether it was signed before or after a new co-owner may have entered the business. So updating these is critical as well. Lastly, is it properly funded? Is this thing going to self-complete as designed? If it's not, a legal binding obligation was created by the agreement with no real way to execute on that obligation. That, of course, can be problematic, as you can imagine, and it leads to business disruption and ultimately the potential for lawsuits. So again, I want to thank you for your time. Daniel, thank you for setting this up. We burned through a lot of information, high level, on what I would argue is one of the most important things that business owners should have in place, and it's also one of the most neglected items in a business owner's arsenal because they've spent a lot of time building their business, growing assets, growing goodwill in the community, and oftentimes these are the types of things that fall by the wayside. I would submit to you that it's your obligation to make sure that your clients are seeing this, are aware of the implications, and we're happy to play a role and guide you through that. If you have any questions, Kip's going to give you an opportunity to submit those in writing. I think it's time for us to turn this back over to Daniel.
Yes, and right before we do, if you don't mind, real quick, Daniel, like Christo said, for our two reasons, compliance purposes, and if you have any additional questions, we ask that you pull out your camera, scan this, just fill out your name, email it. We'll ask for your number, office or mobile. And if you don't mind, if Sarah is going to talk later on a piece about student debt. If you're interested in that, just check that box. If you have any, if you're wanting any information regarding anything Christo spoke on today, please just check off specific information request. And if you're just filling it out for our compliance purposes, then no need to check any boxes. But we appreciate it, and we'll turn it over to you, Daniel.
That was an excellent presentation. Thank you all so much for that. Okay, so now it is my turn to follow that presentation with the topic that probably not everybody's here for, but it's still a very important topic, ethics. And then I'll be turning it over to Sarah, who is here to speak about what y'all are probably really excited to hear about. So I'm going to attempt to share my screen. Right. That looks like that went through. Okay. Can you all see that? All right, looks good. Okay, so thank you for joining me for my portion of the panel. So I work in professional liability defense. So a large part of that is defending lawyers. I have a background in tax, so defend a lot of accountants, the variety of other professionals with licenses that I defend as part of my day job. You may notice that number I put there on the first slide. There are 3 takeaways I'm hoping you all are going to walk away from this relatively short presentation. I talked with a variety of people who were interested in what we're going to be talking about here today. I asked them kind of what they thought was important if we had to talk about ethics in 10 minutes or less. So these are 3 takeaways hopefully everybody's going to walk away with, something to think about or maybe something to incorporate in their practice. So let's go underway. First topic, very important for people who have been to law school, passed the bar, really enjoy having the gold card in the wallet, competency. So that brings us to rule 1.01. Just in case the State Bar wants to audit us based on the ethics portion, we're going to definitely discuss some of these rules. That's an important part of this presentation. So I put the star there. This is basically 30,000 foot overview. Sometimes as a solo or in a small firm, you may not know everything, but you may be associated or affiliated with somebody that's maybe another solo or somebody else in your firm that even though you're the source of the engagement, you might need to bring in somebody to help with. Understanding that and realizing that is kind of the first step of the competency part. Also getting the prior informed consent, that's also critical. Comment 5. That kind of fleshes this out in a little more detail. Comments are always very important to the actual rules. So number 1, takeaway. You're here for the CLE, so you're doing well on this part about competency. Comment 8. You all should be engaging in continuing study and education. So y'all are joining us here today. That's an excellent start on competency. So hopefully that's an important takeaway, that you continue attending CLEs, whether it's through HYLA or through one of the other excellent providers you might have access to, such as the HBA. Okay, next topic, scope of engagement. So especially when you're a solo or in a small firm, the engagement letter is one of those critical things that you need to have spent a lot of time on to make sure that it is in good shape. And it's also one of those things that, just like experience as you go through the years of practicing law, your engagement letters are probably going to get longer and longer just as you get more and more experience. One of my partners that I used to practice with a couple of years ago, we used to have pretty long engagement letters for some of the clients that we worked with. And that was basically because we'd learned from past engagements. One of those things that you want to be careful with is scope of engagement. So that's in Rule 1.02. So this is something you need to discuss with the client. In your engagement letters, you need to actually make sure you specify what you're doing, what you're not doing. To give you an example, so I have a Master of Law in Taxation. Some of the clients would come to me thinking that I was going to be doing this or that, and they were just kind of expecting to get tax advice for free on top. And so that would be important, that if I was representing them in civil litigation that had nothing to do with tax, I was not their tax lawyer. I was their civil litigation attorney, and I was wearing that hat at whatever rate that was going to be at. So, I mean, especially solos and small firms, definitely lawyers need to wear a lot of hats. I know a lot of people who practice in the personal injury space. They also maybe do a little criminal defense. They might do a little bit of civil litigation. They have a different rate for all of that. That's very important depending on what kind of engagement you're going to have. Specify what your rate is, specify, if you're only doing personal injury, you're not their criminal defense attorney, you're not their, civil litigation, business collections attorney, anything like that. So that's really the importance of Rule 1.02. And so for my second takeaway, this is a pop culture reference. You should not try and show off how SMRT you are. You might have experience with tax, you might have experience, in this kind of context with all these other things. If the client is engaging you to do one thing, say just to draft the ILIT or just to draft some kind of trust, make sure that you're not also agreeing to do all this other stuff that you're not planning to. So while you may be capable and you may be competent and you may have prior experience with other clients, just make sure that your scope of engagement is actually what you think it is and what your client has been fully informed about. So as part of that, of course, communication is key. Rule 1.03 is something that a lot of attorneys tend to get in trouble with. Rule 1.03a, lawyers should keep a client reasonably informed about the status of a matter and promptly comply with reasonable requests for information. It's a very simple rule, and sometimes there are issues with it. Sometimes there are intentional issues with it. Sometimes lawyers just get busy. I think everybody can relate to that. And that there's not anything intentional about it. It's just, I can send that update email tomorrow, and then tomorrow you say, oh, I'm busy, how about the next day? And then suddenly the client has no idea what's going on. What is really important and critical on this part is from comment 4. So, I mean, sometimes in our role, you need to give bad news. Sometimes lawyers may feel like they do not want to give the bad news because it's bad news. So that's how that last sentence is really important about not withholding information just to serve a lawyer's own interest or convenience. Something that you'll notice the longer and longer you practice law, clients know bad news is eventually going to come their way. They appreciate just hearing it straight up. And the reason that some people get in trouble is they will tell, or they will say something that will kind of skirt around the issue, and then that creates a whole separate issue. So I guess moving on through the rules, another big one that we want to talk about is 1.15d. So as I've identified it, as Chekhov is gone, that's what the rest of the presentation is going to be about the next couple of minutes. So one of the important things is sometimes you're going to fire a client, sometimes a client's going to fire you. There is the responsibility to surrender papers and property to which the client is entitled. That is a very critical thing. And why is that a critical thing? Why does that matter? So for purposes of this presentation, you can assume that this public domain image is a letter. So you received a letter in the mail. Very exciting. It's something that's actually not a bill. Unfortunately, when you open it, it's a notice letter from your client's new set of legal malpractice lawyers. So there's a couple of things you need to do critically right at that first stage. Of course, contact your carrier. If you've not already contacted them to know that this was coming, sometimes you know it's coming. Sometimes you realize it on your own. And then other times you might just get the letter. So rule 1.15D that we just talked about, something that not everybody knows, but is actually pretty well settled law. The entire client file that the legal malpractice lawyers from the plaintiff are requesting, that includes emails and work products. There's also some really choice quotes you may see in some of those letters you get from the legal malpractice lawyers, that the failure to turn over file is willful and malicious and constitutes dishonorable conduct. There's the site that case comes from, if y'all would like to read that. That is a pretty important opinion to read through. So takeaway on this, lawsuits happen, grievances happen. So you can see here, Morty is the only one that is actually reading the newspaper. The Ricks do not care. They're not bothered by any of this. Morty is pretty upset, it looks like. So you're going to feel like your world is crumbling and exploding whenever you get that first letter. However, there's a lot of things that can be done. If it's still pre-suit, there's still a lot that can be done before anybody will ever find out about this. So there's still a negotiation process that happens pre-suit that's important to keep in mind, which is why as soon as you get that letter from the legal malpractice lawyers, it's important, if you are covered under a professional liability policy, talk to your carrier immediately, because there's still a good window of time to get something done. And then also just keep in mind, these lawsuits are very common. In Harris County, if you search through any of the names that you've heard of other lawyers, you'll see a variety of them have already been sued. It's very, very common. I represent a lot of financial advisors. It happens to them very frequently. They're common targets of this. Same with insurance agents. They're frequent targets. Same with CPAs. This is, I mean, they're very common targets because there are just a lot of these kind of lawsuits. That's something to keep in mind, that just because you've been sued for something doesn't mean that the plaintiff is correct. And also you have to keep in mind there's a whole advocacy process. So in this example, be a Rick and not a Morty. A couple of other potential issues we're just going to go through real quick here. Rule 5.03. If y'all are fortunate enough to be supervising non-lawyers in your office, just take account of the fact they do not have legal training and are not subject to professional discipline, but you are. So that's something you have to keep in mind, that even if you're not the one saying this or saying that thing that really shouldn't be said, but one of your non-legal staff is, guess who is going to get in trouble for that? Rule 5.04, professional independence of a lawyer. In this context, you're going to work with fantastic people like Kip and Christo, who they have lawyers in their family. They know how all of this works, and they provide a very essential, fantastic service. They've worked a large number of years to get a great reputation in the industry. They're not going to have you do anything that's improper, but sometimes you'll be dealing with other people who are trying to get you to share your legal fees with non-lawyers. And there's a lot of other stuff in Rule 5.04. So as you keep in mind that a network with people like Kip and Christo is essential for a successful practice, you just want to keep in mind that there's some stuff you should not be doing when you're working with non-lawyers, especially in kind of a network referral situation. And then Rule 5.05, the unauthorized practice of law. I actually saw this the other day in a mediation where a non-lawyer was representing a client on the other side at mediation, which that was a new thing I'd never seen before, to have UPL that obvious and that drawn out that even the mediator was noticing that. And then, you know, just as a joke at the bottom, you know, be careful about letting non-lawyers do things that are definitely the practice of law. That's something that the state of Texas takes very, very seriously. So as a final wrap up for my ethics section, this comes from Dennis Morton. Some of you I know are familiar with him. Some of y'all are not, but hopefully you will be acquainted with him. If you can't be good, be careful. Want to thank you all for your time. I really appreciate this opportunity to talk to you about ethics. It's a very important thing. Hopefully you all enjoyed that kind of 10-minute walk through ethics, a couple things that I was hoping you all could walk away with. If y'all have any questions throughout the rest of the presentation, drop them in the chat and we'll make sure they get addressed either before we go off or, you know, by email, follow up after. So I'm going to turn it over to Sarah Johnston. Sarah?
Yeah, thanks for the introduction. I'm going to go ahead and share my screen here. Just for the sake of time, I had a longer presentation that was like 20, 25 minutes or so that really just goes over the different types of like federal and private loans. But I'm just going to go over GradFin's process. Then if anyone has questions, just put them in the chat. I feel like that might be more efficient that way. But just to get started, so who is GradFin and exactly what are we doing? So we are a financial wellness institution, really just revolutionizing the way financial advisors and their clients address their student loan debt. So if you're sitting in the audience right now, you have some student loan debt and you're just not sure if you're on the best repayment structure, the most efficient one, what we would do here at GradFin is we would set up a consultation call. So it's pretty much our bread and butter here is this 20 to 30 minute consultation. It's complimentary, so there's no cost to yourself, your advisor. We just simply always want the client to come in with some sort of goal. So we'll get your goals in the first few minutes of the call to see exactly where you stand with your loans. Are you being crushed with your monthly payments? Do you have flexibility? Are you overpaying? So we'll get your goals. We'll get some basic background information from you, like where you went to school, what your income is. We'll have your credit score, things of that nature to make sure that's aligning with our lender's criteria. And then essentially what we'll do next is we're going to break down all the different types of loan options that you have. So just to kind of simplify everything, there are two different types of student loans. There's federal and private. Within federal loans, you have different repayment structures. You have income-driven plans, you have forgiveness options. Right now, all federal loans are in forbearance until May. So essentially you have more protections with federal student loans. So we always don't want to just cut to the chase of refinancing them because refinancing them just doesn't always make sense for every situation. So we always like to stress that we're going to educate on those before anything else. Whereas with a private student loans, the only thing you can really do with a private student loan is just keep refinancing it. So I would say given the current market, interest rate wise, which I'll dive into on a later slide, if you're seeing an interest rate above 4% right now, it's worth looking into refinancing because we're pretty consistently in like the 2 and 3% range. And if we're going to have that refinancing conversation, we act as a broker. So we have 11 different lending partners that we're utilizing and really just working with so many lenders. Essentially, it's just going to give the client more options. Basically, every reputable lending partner in the student loan industry that you can most likely think of is on our platform. So it's just going to save the borrower the time and the energy to shop all of these banks around without really knowing their criteria. That's all built into our model. So it's just going to give the client the highest chance of approval with the lowest interest rate possible. And it's been successful. I mean, we have a 90% approval rating for a successful refi. Industry average out there is somewhere between 30 to 40%. And the reason why I think ours is so high is number one, this consultation approach, because if we ever detect any sort of issue on that call that's not aligning with our lender's criteria, let's just say a debt to income ratio issue, a credit score issue, whatever it may be, we're never going to send that client through the underwriting process until we get that squared away first, as well as just how many banks that we're backed by compared to that average company out there only being their own bank or backed by like another bank or so. So that's basically our process, really just educating on the federal side, speaking about private refinancing options if opportunistic. Just to consider refinancing, there's definitely criteria that goes into it. I would say credit score is probably the factor that's weighed the highest. So 650 or above, we can start the refinancing process. Above 25,000 in income, I know everyone's like a lawyer in this room, so it's not going to be an issue there. And then you're going to have a college education, attorneys, good education, so you're going to get more competitive rates. And then debt to income ratio is also factored in, but I know most people don't know that, so we'll collect your obligations to make sure that's aligning first before we send you through there. It's going to be a lot of information to digest on the call. So you're always going to get a follow-up that's sent over to you. And if you're working with Kip or Christos, they're going to be CC'd on this email as well. Just so you can always converse with them before you make that final decision with what fits into your budget the best. So essentially what this breaks down is the different federal options are your current repayment up top compared to private refi options at the bottom. So if refinancing is opportunistic, it will break down your different terms, your interest rates, your monthly payments, your total cost and cost savings. So like I said, you could always take this back to your advisor. You guys can crunch numbers and really just pick the factor that best fits into your financial plan the best that way. And then really quickly here, I wanted to give refinancing rates because they've been super, super competitive over the past year or so. I know like mortgages have been competitive and auto loans and pretty much everything across the board, but don't forget about the student loans because they are too. I would say generally speaking, anything 4% or above worth looking into. Obviously, like the lower the terms, the lower the interest rates, higher the term, higher the interest rates. But basically for a 5 and a 7 year, like under 2.1%, like under 2% for a 5-year is insane. A 10-year 2.3, 15-year low end 2.6, and a 20-year under 3% is also crazy low. So it's definitely a good time to utilizing refinancing right now. And then some people with higher levels of education will also get discounts built into that to even lower their interest rate even lower. A lot of people don't want to consider refinancing right now because the federal loan forbearance. But what is cool is that some of our lenders are doing a 90-day rate lock, which I think is really cool because people with federal student loans, you can lock in a rate on the private side right now for 90 days. So 90 days takes us to May 1st. So even if this forbearance gets extended again, or if there's some sort of general forgiveness or whatnot, you can always opt out of the refinance, but at least you have the chance to pull the trigger on one of these really good rates before rates do increase. I know the Fed released a statement like last week or the week before about raising interest rates come March. So they're definitely going to increase. So I would say it's better to act sooner than later. And that's everything I have.
Thanks, Sarah. Thanks, Daniel. Thanks everyone for coming out.
Thank you.
Thank you all again to the presenters. Excellent presentations today. Attendees, thank you all for joining us.
Thank you, everyone.
All right, have a great rest of the day, everybody.
Have a great day. Thank you, everybody.